I'm delighted to introduce Rolin Bissell, a partner and member of the management committee at Young Conaway. Rolin is going to lead a panel discussion of board oversight liability 3 years after the Marchand case. He's assembled an impressive panel, which he will introduce, to discuss these recent Delaware cases, which have had and will continue to have significant impact on the behavior of boards and board committees. Rolin has over 30 years of experience assisting companies, their boards and committees, and significant investors with counseling and litigation concerning complex Delaware corporate law issues arising from major transactions, activist campaigns, and corporate crises. He writes and speaks frequently on these issues and has served as an expert witness. It just takes a lot of guts to serve as an expert witness on all these issues. In addition, he's been recognized by chambers, among others, for his achievements. Rolin is a graduate of Columbia University and the University of Virginia Law School. He's a member of a lot of organizations focused on corporate governance. I'm proud to say that he's one of the longest-serving members of the Weinberg Center Advisory Board, and most interestingly, he is the chair of the American Philosophical Society. So without further ado, Rolin, I turn this program over to you.
Well, thank you very much. And I'm chair of the Friends of the American Philosophical Society. The real chair, Linda Greenhouse, would be quite shocked if I didn't make that correction. And I apologize, I'm not going to give long introductions of the three panelists, because what they have to say is so interesting. This is a panel about board oversight and board oversight liability. In other words, when the directors become responsible for bad things that have happened to a corporation. And these three panelists have been involved in many of the cases we're going to be discussing today and actively advising boards and stockholders about how to work through these issues. So I want to get to them really quick. My immediate right is Joel Friedlander, Friedlander and Gorris. He is the investor's choice when the investor feels like he has been shafted and needs protection. He is a great trial lawyer, a great really has worked every side of the issues, but has really done a fantastic job putting together plaintiff side cases, investor side cases over the last a few years, after the last few decades. Also writes a lot. Meredith Kotler from Freshfields, her scope is global, and she represents board of directors of public companies really on 3 continents, and is a trusted advisor to those boards and has wonderful insights about how they work through these sort of issues. And Blake Rohrbacher, to my far right from Richards Layton, has counseled a lot of the companies involved in these cases and can really tell you with direct experience how they deal with these issues, grapple with these issues, and get them resolved. We're also not going to do a lot of background about Caremark doctrine or Marchand itself or the cases that have followed it. There is a set of CLE materials, a PowerPoint, that has all that material laid out. So we're going to, if you want to get more background, history, developments, it's in there. I commend it to you. And let's get straight to the action. And I'd like to ask each of the panelists, starting with Joel, what in your view did Marchand change? And if you could give me about 2 minutes on that, that would be fantastic.
Marchand changed the world. No, at the time Marchand came down, I'd sort of forsworn ever bringing a Caremark case, and I was still, against it. And then by happenstance, this panel, the three of us, we're on a panel together at the PLI on January 10th, 2020. And it was that morning where a tranche of Boeing text messages had made their way into the headlines of the world media about the plane being designed by monkeys and overseen by clowns, or was it clowns and monkeys, and among other things. And we were talking about that at this CLE, PLI. And I think Blake was trying to distinguish Marchand and talk about it. And I remember thinking, I'm not involved in that case, but it seems like there's a problem there. And then we got involved in it. And sort of my theory of the case was that, and I don't know if this is true as a matter of judicial psychology, but my theory of the case was that Marchand was really about Boeing, because when it was argued before Vice Chancellor Slate, I think Vice Chancellor Slate said this is like a novel argument. Someone saying you don't have enough, controls or information systems, and it was like, come on, let's be serious. That's no one's ever really litigated that, much less won it, to say you don't have sufficient oversight systems. And by the time it got argued before the Delaware Supreme Court, you'd had 2 mass fatality crashes, 346 people had died, and the entire fleet had been grounded by all the regulatory agencies worldwide. And then public filings said this a cost of about $20 billion to Boeing. And I can't help but think that had some effect on the decision in Marchand itself by the Delaware Supreme Court. And all of a sudden you went from a standard that seemed kind of toothless to one that all of a sudden seemed very litigable and had teeth in terms of what are the central compliance risks of the company? Do you have regular board level reporting about these central compliance risks? So you can't just say, oh, we have an audit committee, we have an enterprise risk system, we're a regulated company, of course we're doing enough. All of a sudden it seemed like a very litigable in a real way that you had to demonstrate that as a board you were doing things. And I think what came out in Boeing, so I always thought this was a very winnable case. And in discovery, you just try to focus on what the board knew or didn't know and to fit it within Marchand. Am I doing okay on time?
You're a little over, but
Sorry.
I can come back to you because I want to come back to you get more granular on what you're about to get into. But let's hear from Meredith real quick. What in your world would Marchand change?
Sure. First, I just have to say thank you. As the first non-Delaware person on this stage, the bench and the bar in Delaware are the smartest, hardest working, most talented people. It's a pleasure to litigate here and equally welcoming and open. So thank you personally, and thank you on behalf of all of those who don't come from Delaware. And what you heard this morning, all of the chancellors talking about sort of the goals and the hopes for the court. It takes tremendous thought and care and leadership, and I just hope that you all know that it is incredibly recognized and appreciated. So I really felt I should say that as the first non-Delaware person on the dais. My views on Marchand, I actually don't think that the standard of conduct has changed. I think, as many decisions that we have denying motions to dismiss, you have an equal amount or more, actually a few more, granting motions to dismiss since Marchand. And each of the cases, even the ones denying motions to dismiss, repeat that the standards of conduct are not changing. And there's a very interesting decision at the end of Marriott, in which Vice Chancellor Will talks about how even where problems were preventable doesn't create liability. The issue is intent, or that's a big issue. For me, what I think has changed is 2 things: more procedural or context. These claims are now coming after access to internal documents and after the use of 220 demands. There's a real record here that's going to be considered at the pleading stage. And there's good and bad about that. There's a record, and you can work on that record, and you can create that record, and you want to make sure that all of the work is reflected in of board oversight is reflected in that record. So that, to me, is one of the biggest game changers. And the other, from a sort of client or practical perspective, is I do see anecdotally, on behalf of the boards and the directors that we advise, there's a real cognizance of just how important, I think it was always there, but how important it is to formalize processes and to document them again in the record. And I think that those have just been 2 real sea changes, not so much on standards of conduct, but how these cases come about and how they're litigated.
So how they affect how companies are governed is what you're saying.
That's right. And in a way, I think it's a very positive change. It's more good corporate governance, organizing processes and procedures, making sure you have them in place formally, and making sure that there's a proper record of everything that's going on.
Thank you. Blake, what's Marchand changed in your world?
And first, I'll start by, this may become clear throughout the presentation, but Joel and I were on the opposite sides of Boeing, so I will stipulate that I disagree with everything that Joel will say for the rest of the day. So, to me, Marchand changed a few things. One is that this was the first time the Delaware Supreme Court reversed a Caremark dismissal. And so that alone means something. It means that and I do think there was a change from the way the previous law at least was interpreted, but the Supreme Court wanted to see Caremark claims survive motions to dismiss. And so I think that had a ripple effect on everything we've seen. And before then, it was great to be a defense lawyer on a Caremark claim. I don't know, there might have been one, but really you won them all. And it was good times. So, so when you saw a Caremark claim, no matter how terrible the things that happened and no matter how terrible the allegations were, you knew you were going to win it, and it was kind of nice to go in. Marchand provided a roadmap, I think, for plaintiffs to follow. And now, if there is not a board committee specifically tasked with the issue complained about, the plaintiff has a chance of surviving. Marchand was also interesting because it was a prong one case. So nearly every Caremark case that had been brought until that point was a prong two case. Corporate trauma happened, and the plaintiffs would allege that the directors had failed to act in response. But by pleading a prong two case, the plaintiffs, by saying there was the committee charter and this corporate guidelines and this committee structure, they would plead themselves out of a prong one case. And so most of the Caremark history of cases was plaintiffs intentionally or unintentionally, but giving up their prong one claims, and Marchand was really the first prong one case to make it big. And so it gave life and hope to the idea of a prong one case. And again, I think in a way designed to make these cases easier to plead. And what we have now is this interesting time where the post-Marchand denials of motion to dismiss are of companies whose governance was in a pre-Marchand time period. And so I think to Meredith's point, I think once we get to a time where the governance that's being challenged is itself post-Marchand, then whether it goes away or it becomes different, that's what we're going to look to see.
Okay, great. I'm going to come back to Joel for a moment. I mean, the old saw about Caremark claims, and I think it survives Marchand. Hardest to plead, hardest to prove. And the courts are saying that's still true, given that there's still a very high bar that you've got to clear, Joel. I mean, what do you look at when you're looking from a stockholder plaintiff's perspective? This is a case that could clear one of those bars. And what are you doing practically to make that happen?
Well, I hate to be like a one-trick pony, but I'm sort of involved in like Boeing, and I don't have like I don't think there's a template going forward, and because I think a lot of it is the fact that we have pre-Marchand fact situations. I think the real dramatic thing is that the Marchand decision, I think, really changed, like for the people in this room and people advising corporations, really changed expectations in the boardroom, and really called out behavior that might have been seen as good director behavior by as to be really reprehensible. So to take the Boeing facts, and actually Boeing is sort of an interesting prong one case. Like there was no board level supervision before the first crash went down, but really the strongest claim was the prong two case, which is, okay, a plane has crashed, what are you going to is there something amiss here? Should we be doing something about it? Like, a red flag in the old Caremark parlance. And what we saw was, when you look at some of the comments of the directors at the time, who are very, very reputable people. So after the second plane crashes, and the CEO is desperately calling Elaine Chao, Secretary of Transportation, calling Donald Trump, lobbying very hard to keep the FAA in the air after every other regulator has grounded the plane, and successfully for one day until more data came out, and then it got grounded by the FAA the day later. But that night after the first day, Edward Liddy, former interim chairman of AIG, sends an email to the CEO. I, for one, really appreciate the strong leadership you're demonstrating in a very challenging situation. your leadership will prevail. And that's not quoted in the opinion. And I don't think in a post-Marchand world, the idea that you've had 2 planes crash and they're plausibly related to a defect in whether your plane is airworthy, and the idea that you can brusquely treat this as public relations or investor relations or government relations, and the job of directors is to keep the pipeline running, keep the revenues coming in, keep the planes in the air. That's no longer the message from the Delaware courts, that your only job is to keep the profits and keep the revenues going. So that's what I mean when I say the vibes have really changed. And I don't know if it'll really replicate itself in a world in which advisors are telling boards how they should react in these kind of situations.
How important to, because Boeing obviously survived a motion to dismiss. How important was the 220 action that you guys brought to get corporate records before filing to the complaint being successful? And is that pretty much a prerequisite to anyone who wants to have any hope of bringing a successful Marchand or Caremark claim?
Well, as to Boeing, yes and no, because what made Boeing really unique was you had a tremendous release of information because of government investigations. So there's just a tremendous amount of public stuff. Like, for instance, like when we were amending our complaint, the company pleaded guilty to a crime, with defrauding the FAA, and it was public that they had not basically provided information to a DOJ investigation into whether they defrauded the FAA, and the FAA got really pissed off and sent them a letter saying, why are we finding this out months later? So that was, you don't need 220, but that's an unusual case. But what you do get in the 220 are some of these texts and emails about what the directors were thinking. So when you have Kenneth Duberstein, just recently deceased, former chief of staff to the White House, really the architect, I'd say, of the Boeing corporate governance. He'd been at McDonnell Douglas, and Boeing had acquired McDonnell Douglas. And his quote at the time of the first crash, "Press is terrible, very tough, lots of negative chatter I'm picking up, not pleasant. We need to address it more aggressively, concerns merging 737 line deliveries and Lion Air." So it's a press problem. It's an investor relations problem. And you get that from the 220. You get the former CEO of Medtronic saying, hey, why don't we try, now that the planes have been grounded, why don't we try doing what we did at Medtronic, which is have reports about safety and product quality at every board meeting so people in the company know we care about these things. That's what you get from 220.
Yeah. Well, that's great, Joel. Meredith, you mentioned in your earlier remarks that some cases get dismissed and some cases don't get dismissed. And so if you're on the defense side, what are there any patterns that you should be looking at when you're advising a board? Like, you need to fight this thing, you need to settle this thing, you need to come up with plan B, but whatever.
Yeah, I'll step back for a minute. I think some of the most helpful advice that you can give post-Marchand comes months, years before and corporate trauma takes place, right? It's going back to the boardroom and formalizing processes. I will say, just to respond to something that Joel said, remember, when you get documents in a 220, that's not full discovery, right? It's a certain paper record, and all of the decisions denying motions to dismiss, we all remember, and each of the courts repeated it. They're done at the pleading stage where every inference has to be taken in favor of the plaintiffs, and you can read texts and you can read emails out of context, right? And that, coupled with with inferences, means that the plaintiffs can tell a narrative, and there may very well be many other facts and other thoughts there for later in the day. And I say this only because it goes to your question a little bit, Rolin, which is, how do you best advise somebody when they're in the middle of when a litigation comes in? Well, hopefully you've been advising that board now for quite some period of time, and long before, and again, that boards are cognizant of how things can look later, right, after based on a record at the pleading stage with inferences taken for the plaintiffs and with limited documents that are set. The other thing I would say is that when you look at the cases where dismissals were denied, they're pretty unusual and extreme situations, right? Airplanes falling from the sky, people dying of listeria, pipeline explosions, right? A company taking the overfill from syringes and putting them into other syringes and selling them. Those are, understandably extreme situations and should be called out. And equally, again, on the other side, though, you see a series of decisions that are more, I hesitate to use the word garden variety, but that you see far more often, right? So a company adjusts its revenue guidance, or they've got a product that's in, the approval process, and the FDA maybe expresses doubt about the path going forward, or a company that ends up with a, government or regulatory action filed against them, or a regulatory settlement and fine. And so I think, again, most of the situations that one deals with in advising companies, in my view, tend to fall on that side of the line. And those are some of the patterns that I see.
Okay. Blake, I think you said earlier that like one of your favorite things in life was to file motions to dismiss Caremark claims because they always got granted, and clients were always, impressed by your acumen and skill. And like, has that changed? Do you now have to tell them, I don't get to do my favorite thing, and you don't get because you're not going to win your motion to dismiss? I mean, has your approach to the motion to dismiss changed?
Those were good days. So again, and I will repeat my stipulation about what everything Joel said, but so things are different now. And it's not just from Marchand, it's also different because every derivative case, I think I can safely say every derivative case now that's filed in Delaware has grown out of a 220 demand. And when I started practicing, there was a great transcript by Vice Chancellor Lamb that said, I would never give emails in a Section 220 demand. And as everyone in this room knows, the last 15 years or so have not been kind to that proposition. And so before Joel's complaint was filed, we had litigated a 220 action against a different plaintiff, and in settling that ended up giving about 40,000 documents, which is 1,000 times more than any other 220 I've been involved in. And so the cases are different now. They start from the stronger informational base. The Vice Chancellor's opinion in Boeing states that she was able to find Scienter because there was an email from one director to another saying we should put we should talk about safety. Now, I'm prevented from all sorts of doctrines, including privilege, from talking about really what the truth was, but
we have the full quote of the email if you want.
The fact is that if you're a litigator and you're worried about your clients sending emails, stay worried, because the use of 220 now, and the fact that the complaint is going to be the plaintiff's story, and you don't get a chance to tell your story until trial, which thus far has never happened. And so, to Meredith's point, your defense begins years before anything ever happens. It's creating the corporate record. And one point I'll make on motion to dismiss is that the court, quite rightly in many situations, and Joel and his friends, rightly or wrongly in many situations, complain a lot about incorporation of the 220 production into the complaint for use in a motion to dismiss. And certainly there are points where that is an appropriate criticism. But when you're talking about a Marchand case, incorporation is more important than almost any other place, because Joel's complaint is you don't have a reporting structure. Well, what if we have in all of these board minutes proof of a reporting structure? So in a Marchand case, you need incorporation by reference because it's too easy. In a red flag case, he has to prove, well, you saw a red flag. So he has to at least put some set of minutes into the record to prove that the board knew of something, and then you can see what happened in the real world. But in a Marchand context, without a lot of incorporation by reference, a plaintiff can say, well, there was no reporting system, even though we produced detailed evidence of a reporting system. So that's one, that's one aspect. That's really the only thing that the defendants have in the motion to dismiss, is the ability to show from the corporate records that are produced that there is a reporting system, that there are committees and board minutes that show the discussion.
And the treatment of red flags and the consideration of red flags. And the other thing I'll just add is that it puts a lot of pressure. Somebody said it this morning, maybe a couple of the chancellors noted it. It puts a lot of pressure as litigators on what you redact and what you don't redact, and create, making sure you've got, and I think this is a good thing, a good record that, the court can review to sort of really understand, okay, you have a plaintiff's narrative in the complaint, and now I've got the, whatever it is, the set record that can be considered on the motion to dismiss. And when you've got pages with big blocks of redactions, nobody benefits from that. And I think that has, from a litigator's perspective, tremendously changed the way that we think about the preparation of minutes, and where you put privileged advice and where you don't. Because ultimately, whether it's a couple months away, a couple years away, hopefully never, if something bad happens and that record has to see the light of day on a motion to dismiss, boards are very cognizant that they're gonna want, a full, adequate, non-redacted set of documents to see.
So a Marchand motion to dismiss is best drafted years before, when the minutes are done, and then months, maybe years after that, when the 220 production is done, and then what ends up in the brief is really a function of those two things.
Great. I mean, does do you think you're encouraging your clients to be maybe less parsimonious in 220 productions in the Caremark area? I mean, typically, you were talking earlier about that it's a shame you now have to produce emails and things like that, but are you a little more open-handed at the 220 stage, because there's stuff that can help you?
Certainly with board level materials, that is true. Emails are still difficult because Joel and I will fight about whether you can never really win that fight unless you essentially produce every email in the company, because there's always going to be some sort of limitation, and unless you do a full discovery sort of review of documents, you're not going to know which emails to include, and then Joel's going to refuse to allow you to incorporate them because he'll say, well, there might be other emails in there. And so board minutes is really being generous with board minute production, board material production, I think is.
So get it into the minutes and then let them fly.
These days, that's the best you can do.
And not just minutes, though. I mean, there are many other formal corporate records, right? There's board books, there's agendas, many other things. Maybe I'm a good student, but I read the decisions carefully, and I'm very proud that I haven't had any 220 cases actually be litigated, because we try to listen to what the court has signaled and do. I think there has been there's been a spectrum of wonderfulness, I guess that's a new word we can use after this morning, of wonderfulness, I guess, amongst law firms. But many of us have gotten the clear message, I think even a couple of years ago, and see again the benefits of producing the formal corporate records. And by the way, because you may never get a lawsuit, right? I mean, we have those situations too, where you produce the documents and I've done presentations, right? Presentations to stockholders counsel and walked them through and said, here's why I think you've got the wrong idea here and what's going on, and that happens too.
Great. Now, Joel, you look like you're ready to pounce. If it's in rebuttal, you may do so. If you're just reading another greatest hit, you'll be ruled out of order. So, which is it?
No. It was just rebuttal to Blake a little bit. There were tons of documents that were incorporated by reference in Boeing, and all these various documents, and even we amended our complaint to say, well, it's great, they attach all these documents, but actually they don't reflect board consideration of safety in a relevant way. And I think that really goes to how Marchand changed the law and the expectations, that you had to have board level safety reporting, and just maybe having the word safety in some document from below at some lower level won't do the job. So I think the court had a pretty comprehensive view of the enterprise risk system, but it didn't meet the new requirement, I'd say, of Marchand of are you focused on a mission critical risk, flight plane safety, at the board level in some regular way, and that really was a rule. Now we didn't see the privilege stuff, but so who knows how things would have shaken out if we hadn't settled, but or if we ever would have seen that. But there was a pretty full record that was incorporated by reference.
Okay, Meredith mentioned that the motion to dismiss is a plaintiff-friendly standard in the sense that inferences are drawn in favor of what the plaintiff has alleged. But the winning a motion to dismiss isn't the end of the game. That's just the ticket to discovery. Because so few motions to dismiss have ever been granted in the Caremark or have been denied in the Caremark context, there's not a lot of history, of litigation history about what comes next. But one thing that does pop up that's been used in a lot of other derivative litigation is a creature called the Special Litigation Committee, which is a committee of the board who takes control of the claim. And I'm wondering if Meredith could lead us through just sort of the basics of how that works and how it can be a little bit tricky to put together a special litigation committee after a motion to dismiss has been denied.
Well, I actually think here it's not all that different, as you mentioned, Rolin. The special litigation committees have been around for a long time and are used quite often in derivative suits, right? I mean, the key is you've got to have an independent, disinterested committee, right, of some size that can handle it, and sometimes that can be, hard depending on the allegations. If folks were on the board at the time of, whatever's the corporate trauma that led to the lawsuit, right, then they might theoretically face a substantial likelihood of liability. Sometimes people talk about adding new directors, which is always interesting, and I've been involved in a number of those situations. That can be tricky. Sort of as a procedural matter, it's easy, right? Most bylaws will allow, a board to vote to increase the number of seats on the board, and then the directors can vote in a new director or two, to fill the new seats and the vacancies. So procedurally you can do it, but there are all sorts of dynamics, right? There aren't necessarily people waiting in the wings who can just step in and join a board, and then who will mesh, and the personalities will be right. And so often it can be done, but it often takes time. And I just reread the very interesting the Graf-Tech decision from the Chancellor a few weeks ago, which was really interesting, and I think probably should have gotten a lot more notice from folks at the time, because there was a really interesting allegation there, which was that an additional 9th director had been appointed, and then the first question was, could that director, was that new seat properly created under the stockholders agreement? And the court did the analysis and found that it was, but there was a breach of fiduciary duty claim because the 9th director getting appointed tipped the balance for demand futility purposes, and now you had with this new director, you had a majority of the board that was independent, or the defendants could argue was independent, and the plaintiffs had alleged that there was a breach of fiduciary duty by creating the vacancy and putting on the new director. And that's you can imagine that happening, right? In that scenario, happening if you're trying to create a special litigation committee and you need to add a new director for that, you could end up with charges of breach of fiduciary duty. But interestingly, the opinion reasoned that director vacancies happen, new directors get appointed all the time, and there are salutary purposes for doing this. And she rejected that claim. But it was a really interesting opinion, and I think something you might see more of as if you have to appoint new directors.
Because it just occurred to me, I'm going to throw you a wild pitch. What do you do to get directors ready for how much work they're going to have to do if they serve on a special litigation committee? And do you ever get the response, you want me to do what?
Yes and yes. Look, first of all, serving as a public company director is not an easy thing, and there's a lot of work you have to do when people come on to public boards, and frankly, that's the beginning of our work, right, and hopefully avoid so many of the issues in litigation going forward. But yes, there's a tremendous amount of work that you have to do to sit on a special litigation committee, and I've found that it's best to be upfront about that and to get those kinds of time commitments and you know, rolling up your sleeves and really being involved. I mean, you want members of a special litigation committee at witness interviews, reviewing the documents, right, and really digging in. Those are the best members, of course, also with good counsel, but you've got to find the right person who's got the desire and the interest in doing that. But you know, just as you have to do that, I often find, at least in my practice, that we find those people. It's not everybody, but you find many of them, and they take the job very seriously.
Okay, well, that's standing up the special litigation committee. Blake, maybe you can walk us through just an overview of how the special litigation committee process works, so people have an understanding of it in general, because I want to get to you and Joel's and your experience in Boeing, but sort of knowing how the special litigation committee process works and where it ends would be a great help in setting that up.
Yeah, so I'll give you the nine months in 2 minutes. So it starts when the SLC is formed and then retains counsel. Invariably, they move to stay the litigation, and Joel will oppose it, but you know, generally the law is that when an SLC comes in, the litigation gets stayed so that they have time to do their work. Then the hard work begins, and often, you know, particularly given the nature of Caremark cases, there are other issues going on. So, for example, the SLC that was appointed in Marchand was delayed because of a DOJ criminal proceedings, and so, you know, there are always these often these outside issues, but essentially it's digging in, and really it's not that dissimilar from one-sided litigation. They send out document demands to the defendants, to the company, to third parties. They crunch through that. They interview the people involved, and you know, essentially do an investigative side of the litigation. Then the committee and their counsel put together usually a fairly detailed, multi-hundred-page report, and then that's when the interesting different decisions happen. Clovis, which Clovis was, the motion to dismiss was denied shortly after Marchand was decided. An SLC was appointed, and after the SLC filed their motion to terminate the litigation along with their report, and just in the last couple of weeks we filed a stipulation of settlement. So the SLC can decide to dismiss the whole litigation, which I think is happening in one of these post-Marchand Caremark cases. It can do the investigation and then settle, work out a settlement with the plaintiffs. It theoretically can also say, yeah, it looks like there's a claim here, hand it off to the plaintiffs or litigate it themselves. I'm not sure that that has happened yet in the the post-Marchand world. But post-settlement, the SLC has a lot of flexibility to stop the litigation, settle litigation, or keep it going.
Well, but it's not the SLC's decision by itself. I mean, it files a motion to dismiss, and what does the court do about that motion? Does it just rubber stamp it, or is there a little more involved than that?
No. So if the SLC decides to terminate the litigation over the objection of the plaintiff, then we get to go back to the oldies but goodies of Zapata, which essentially the plaintiff will get to take discovery of the SLC's investigation, and then it's more or less a summary judgment standard by the SLC to get out of the litigation, and there's two factors. One is, was the investigation done in good faith and reasonably, and then there's a second factor where the court decides whether terminating the litigation on the terms that the SLC desires is in the court's business judgment the right thing.
Okay, so there's a standard of review, and it would be fair to say that's not as plaintiff-friendly as a motion to dismiss, but not a walk in the park for the defendants either.
I think that's fair. I mean, I'm imagining we're going to soon have a resurgence of Zapata litigation, given all the post-Marchand SLCs. But yeah, it's the SLC's burden to show, and that interesting kind of X factor is the court's business judgment and deciding whether, given everything that's going on in the case, is termination or this settlement that's proposed by the SLC the right thing.
Okay, now getting back to Boeing, Joel has his magnificent victory on the motion to dismiss. You've got the SLC that you can do, which seems like a pretty potent weapon to take control of the litigation, but somehow the two of you decided, well, probably more than just the two of you, that maybe we won't go through the SLC process and maybe we'll settle. And it was a quick settlement and a big settlement, and to the extent you can, what drove that decision? What was in it for the plaintiff and the defendant to come to that quick decision as opposed to grind through the considerable SLC process that held out the potential for you, Blake, of maybe getting rid of the whole litigation, and held out if Joel could beat you again at the SLC stage, he maybe could put an order of magnitude in addition to the
37.5.
Thank you. 30 million he was able to negotiate.
I'm guessing I can speak more freely than Blake can on this subject. So, sure. Yeah, no, it was pretty clear to us that there was going to be an SLC, but frankly, in a lot of derivative practice last few years, we've been fighting through SLCs in various ways in a bunch of cases. Most notably in Oracle, where the Special Litigation Committee gave back to the plaintiffs the case against Larry Ellison and Saffron Katz about the acquisition of NetSuite, which is going to trial this summer. And what I thought in the Boeing situation was that the company really did not want to create an SLC. I'm sure they would have, but I don't think they wanted to, because I didn't see how it was going to vindicate the defendants. I don't know how they're going to vindicate the former CEO, who, again, was aware of the text messages that were later admitted to be a crime, that they defrauded the FAA and didn't bring it before the board, apparently, to discuss the implications of that before the second crash. So I thought that we had a lot of leverage, and that the company would not want the protracted litigation, publicity, and risks associated with an SLC process and then a post-SLC litigation process. So I think that enabled us to strike the settlement. I'm not sure it was that quick, given the 44,000 pages of documents and the motion to dismiss decision and all that, but that's how I looked at it.
Blake, what, if anything, can you share with us, or would you like to pass?
Yeah, no. So I will be careful, and I will make one kind of initial point on SLCs. SLCs, by their definition, cannot be controlled by any of the parties. Now that causes some risk to Joel, because he doesn't get to litigate for 6 to 9 to 12 months, depending on how long, and he doesn't really have control over what the SLC's decision is. But it was a cautionary tale. Neither do the defendants. The SLC, once appointed and once empowered, does whatever the SLC wants to do, regardless of which side thinks it's a good idea. So it's a bit of it's something that can't be controlled, and so once you start it, it has a mind of its own. But I do think, and I know Joel said this at the settlement hearing, that he didn't think that SLC, future possibility of an SLC mattered that much, but it does change the dynamic, and it takes control, certainly, of the litigation out of Joel's hands at the time. Joel is right. This was not as quick a settlement as it looks. And this is public. This settlement process happened before the motion to dismiss decision even came out. The parties were in mediation before the decision came out. So it's not like the motion to dismiss was denied and everybody jumped into the settlement room. There was a long process before that. And I will also say, I don't know that Boeing is necessarily a pattern for post-denial settlements. I'm not sure how repeatable it is. In the pre-Trulia disclosure cases, the court would often not approve or would question a settlement where there weren't depositions or even if confirmatory discovery seemed too friendly. But here, there were 40,000 documents produced, which is more than in many litigations. Joel's co-counsel in their affidavit said they spent nearly 10,000 hours just the motion to dismiss stage. So rarely are litigants going to be in that position where, again, certainly a partial record from our perspective, but that much of a record is already out there. So I'm not sure that the quick settlement is the new is going to be the new fashion.
Okay, we've got about 3 minutes left. Meredith, if you would like to add anything about, I've got no minutes left. Okay, I've been timing. Anything further you want to say about SLC? Then maybe you can start us off on the last question. Each of you have a little less than a minute. What can directors do now to make sure that they're fulfilling their oversight duties and thus protect against potential oversight claims? So use your time any way you like.
Wisely. Yeah, I think, look, I think this, maybe it came out of Marchand, but I think many boards did this already, but now they think about it more in a more formalistic and more formal and record-creating way. But make sure you've got processes, right, to identify your key risks, to have them discussed at the board level. I'm not one in the camp who thinks there has to be a special committee or a separate committee on every single kind of risk. I think there has to be appropriate consideration and oversight at the board level, however a board considers and thinks that's appropriate. That you're refreshing on what those risks are every year, that everything is that the management and others are reporting up to the board, that the board is discussing, it's asking questions, it's asking for follow-up, and then most importantly that all of that probably is going on anyway is being documented in the record, because that's what's going to be seen at the pleading stage if and when something goes bad.
Okay, great. Joel, I'll let you go next, and I'll let Blake have the last word. So there's a check on your license.
Oh, I was just going to waive my Marchand time and just say thank you. I appreciate being here. Actually, John Weinberg's a distant cousin of mine who I met once, and so it's a pleasure to be here.
Well, thank you, Joel. It's great to have you here. Blake, do you want to end the era of good feeling by making a last-minute grenade, or just?
No, I will. I will agree with what Meredith said. I think now. Marchand was a bit of a rule change, in the middle of time, and I think now that we see how these cases are going to be judged, I think Meredith's right. It is a matter of making the record, doing the work, and making the record.
Okay, great. Thank you all. We appreciate your attention.
Thank you, Rolin, on behalf of the center, and thank you all, Joel, Meredith, Blake. Thanks so much. It was interesting to see all sides of the equation there, and we really appreciate that robust discussion. As Jennifer, I think we need to change some. Oh, we do it. Okay. Jennifer brings her panel up. I wanted to introduce her and just refer to the fact that she's assembled a very distinguished panel that's going to talk about special board committees and SPACs, which are special purpose acquisition corporations. They've gotten quite a bit of publicity in the last year or so, both at the state and at the federal level. And I just want to, before Jennifer introduces her panel, I just want to tell you a little bit about her. She is a partner at Skadden here in Delaware. She is a sought-after litigator for complex litigation at both the state and the federal level, involving mostly fiduciary duty challenges, derivative claims, and contract and commercial disputes. In addition to her practice, she does a fair amount of writing, including serving as co-author of a seminal 4-volume treatise on corporate law entitled Folk on Delaware General Corporation Law. She is consistently recognized in the lists of the best, and she also is a fellow in a trial lawyer honorary society called Litigation Council of America. She is a graduate of Georgetown University, the University of Chicago Law School, and I'm proud to say she's a member of the Weinberg Center Advisory Board.
Thank you very much, Justin.
And just sort of an administrative announcement, we're going to go until 12:45. I know that we sort of thought we were going to conclude at 12:30, but just want you to get the full benefit of the panel here. Thanks.
I had planned on striking all of my comments and letting them talk, but now that we have that extra time, I appreciate it. Thank you for the kind words. I'm very happy to be here today. I'm joined by Mike Barlow, who is a partner at Abrams Laster. That's one of Delaware's. Abrams Bay. It's one of Delaware's premier litigation boutiques. Before joining that firm, Mike served as chief legal counsel to Governor Markell. His firm represents defendants in the Pattern Energy case, which will be a focal point of the special committee discussion. Next to Mike is Mark Lebovitch. Mark is a partner at Bernstein Litowitz, where he co-leads the firm's corporate governance litigation practice. He was recently named Attorney of the Year by the New York Law Journal, and he has successfully pursued many cases in and outside of Delaware on behalf of institutional investor clients. He's currently litigating the SPAC case in Delaware Multiplan and has various other SPAC cases in state and federal courts. And finally, Patricia Vella. Tricia is a partner at Morris Nichols. She advises clients on transactional work, including special committees and SPACs. She's vice chair of the ABA's Mergers and Acquisitions Committee, and she frequently speaks throughout the country on Delaware corporate law issues. So I'm really grateful that y'all accepted and are members of the panel.
Thanks, Jennifer. And if I can say, I'm also a blue hen and a fellow Sussex Countyan with Chancellor Chandler.
As is Mike, so. First topic today is special committees. We're going to talk about those in transactional context. Last year, we saw two cases, Empire Resorts and Pattern Energy, where bad faith was successfully pled against special committees, and I think this is a rarity. Interestingly, you'll see, and Michael discussed this, in the Pattern Energy case, most of the key attributes of a well-functioning special committee were found there, but still the court found bad faith and refused to dismiss the case. Mike's going to summarize these, and hopefully Tricia, as our transactional expert, is going to weigh in on, when advising a special committee, perhaps how to sidestep some of the issues and problems that were found in these two cases. In addition, we're going to touch on what I think is a very important part of Pattern Energy, and that is the court's discussion of Delaware's, I think, evolving views on controlling stockholders. What is a controlling stockholder, and the consequences of this? Among other things, this has implications for the use of certain procedural safeguards, including the establishment of special committees. So with that, let me turn it over to Mike.
Afternoon, or good morning, everybody. So by way of segue, I started my legal career in this building. I didn't know it at the time. I was a University of Delaware student, and one of my jobs was to work at new student orientation, where they bring in all the students to this building over the summer before they start as freshmen, and they sort of they pick their courses and all that kind of stuff. But an important part of the process was they bring all the parents into the big conference room across the way, or at least they did 30 years ago. And they get a panel of students up here to talk about what the experience is like as a student. And my job at the time was to explain the federal educational privacy law to parents to explain that they were no longer going to be able to get access through the university to the grades of their students. Which, as you can imagine, as a parent sending off your kid to college was a really hard thing to hear. And I guess at that point I didn't realize it at the time, but I was really doing what I think a lot of good lawyering involves, which is giving hard advice and explaining hard facts to an audience that doesn't want to hear it. My suggestion would be to anybody, don't do that to 1,000 parents. That goes really badly. But the segue here is we're going to talk a little bit about special committees. And special committees in particular are the kind of organization that, when established under Delaware law, really need to talk about hard truths and hard facts. And Delaware law and Delaware cases for many years, both before and after the MFW decision, have promoted special committees as a institutional vehicle to create arm's length bargaining where it otherwise wouldn't exist. And in this context, when the Delaware courts do that, they are expecting the special committee to tell hard truths, to act as independently, to act disinterestedly, to act in good faith, and to advocate vigorously on behalf of the stockholders they represent. And through MFW, you've seen a promotion where controlling stockholders realize the wisdom of setting up special committees, as well as adopting majority of the minority voting provisions that help protect the transaction from a subsequent challenge and second guessing by plaintiffs' lawyers like Mark. So the interesting part about serving on a special committee and telling those hard truths is your independence and disinterestedness is going to be challenged. That is a sort of the beginning of the process. You need to actually be fundamentally someone who's willing and capable of representing on a manner that's adverse to the controller of a corporation to vigorously represent the interests of stockholders. And that, I think everyone accepts that going in. And what's interesting about the two cases that we're going to talk about today is those are cases in which the independence and disinterestedness of the special committee members was not in question. That the question was, can those special committee members get out of litigation risk, even if they're totally independent of the controller, totally disinterested in the transaction, and the focus instead is entirely on what they did and the process they invoked and the decision making they made. And so that falls into what we typically call as the sort of bad faith situation. As a matter of due care, that those directors are going to be exculpated under 102B7 from claims, and so and you're acting consistently, generally, with what we think of the traditional duty of loyalty because you're disinterested and independent, but we talk about bad faith as sort of a safety valve, and we talk about it, the quote has always been, you only have bad faith where it's qualitatively different from an inadequate or flawed effort to obtain the highest value reasonably available for a corporation, right? So bad faith needs to rise to a level that is qualitatively different from just a duty of care violation. So the two cases we're going to talk about are Empire Resorts and the Pattern Energy case, but they both fundamentally involve process failings that, as alleged, and I should be very clear, although my firm is involved in the Pattern Energy case, I'm not involved in it at all, and all these facts are as alleged because they are motion to dismiss decisions. They are all fundamentally decisions in which the process is challenged, and so situations in which independent and disinterested directors were not let out of the case at the pleading stage. Empire Resorts is interesting because it's a very quick deal process, and I would commend to anybody, it's available, although it's a transcript decision, it's available on the Weinberg website. The fundamental situation was the company operated a casino in the Catskills, and the company was considering opening a new casino slightly closer to New York City and populated areas than their original casino. And on the eve of that, the controller decided that they wanted to take the company private. The facts are laid out in the transcript decision in far more detail than I'll lay out here, But in broad terms, at that moment, they decided to set up a special committee to negotiate against a controller who owed 88% of the stock. And the process from the outset, as alleged, involved a number of failings, including the full company board deciding who the advisors were going to be to the special committee, and impaneling and hiring a financial advisor and a legal advisor that were long-term advisors to the company, as opposed to newly hired people by the special committee. You also see in Empire Resorts the allegation that management was involved in the process. Management was involved in the process in a very substantive way in generating both all of the negotiations as well as the projections that are so important to valuing a particular company. And then the other concern that was evidenced in the opinion was, though management and non-independent directors were in the room with the special committee, there were also demonstrated leaks out of the special committee room that went up to the controller. And there was no evidence in the record, at least documented in the minutes, that the special committee did anything about it. And so those set of facts caused the court to essentially decide that the motion to dismiss the special committee could be denied because it rose to the level of bad faith. And it did so under what we call the conscious disregard standard, that the directors consciously disregarded their duty to act in the best interest of the stockholders by failing to essentially police the process for the influence of the controller. And there are a number of other issues that the controller did, but those were the foundation of why that case wasn't dismissed. And just to compare Pattern Energy, again, another situation in which we'll talk a little bit about whether or not there was a controller there, but another situation where a special committee is asked to essentially negotiate against a controller to consider a sale of the company. And why Pattern Energy is fundamentally different is in Pattern Energy, the court goes beyond the sort of conscious disregard and actually acknowledges that the special committee did not consciously disregard its duty, that the special committee actually did police the involvement of management. In Pattern Energy, the special committee that was set up to negotiate against the controller actually established not one, but two protocols to manage how the CEO and the CFO could engage with interested bidders. So there was an actual attempt to control that process. In addition, Pattern Energy was a process that lasted more than a year. They brought multiple bidders to the table. Those bidders were pushed up, multiple third-party bidders for the company, before eventually agreeing to a transaction with a controller. And so the court was put in an interesting position of saying, this is not conscious disregard. This is not a situation where the directors didn't do what they needed to do, at least for purposes of the allegations at the motion to dismiss stage, to police the potential involvement of conflicted management and conflicted controllers. But the court found, in fact, that there was still bad faith, looking fundamentally at the decision that was made by those directors under the Revlon standard to decide to approve a sale of the company to a company that was friendly to the alleged controller. In that case, taking, as alleged in the complaint, a below value deal, taking a deal that was substantially less than a third-party acquirer was going to pay, because the friendly acquirer had a strong relationship to the controller. And so in that case, they adopted they took a different approach to bad faith. It wasn't just a conscious disregard of duty, but instead made a decision that acknowledged those directors made a decision other than what was adopting the best value reasonably available to stockholders, and a decision that fundamentally fell outside the range of reasonableness. So those were the two factors that got you into bad faith in those decisions. And why I think they're particularly important is because being on a special committee is hard, and no process, I think, anybody would recognize is always going to be perfect. But those two cases really test the edges of where do process failures and fundamental special committee decision making get to a point that a special committee, otherwise disinterested and independent, will nonetheless find themselves facing personal liability for approving a transaction for which they thought they were on the other side of the table.
Tricia, let me turn to you for a second. You're a transactional lawyer. In light of these opinions, in particular Pattern Energy, and before we start talking about the controller issues, sort of how do you advise a special committee at the outset in order to avoid a situation like Pattern Energy where, you know, all the boxes seem to be checked, nevertheless there's a bad faith finding?
Yeah, and that's candidly a hard question to answer. I think I'd like to answer it by looking at Empire and thinking about the things that came across from the court in the transcript, because I think the court sets out a roadmap to a certain extent of what the committee could have done and what transactional planners should be thinking. Number one, with respect to the leaks that were coming out of the special committee and that members of management were involved, and doesn't say necessarily who the leaks had come from, but there's a suggestion that it was perhaps from some members of management. And look, that happens at times when you are advising special committees. They could be inadvertent at times. I think the issue that the court took was that there was nothing on the record that the committee knew about it or did anything about it. I wonder if it would have been different if there was an admonishment in the minutes directed to management saying, no, you can't do this, a la what they sort of in Pattern, where they put the rules of the road in place and said, management, you can't go out and have these discussions without us, or you can't do it before we know about it, or we have to authorize it. Or perhaps having a chaperone involved, either the chair of the committee to the extent the committee member has the time, or the financial advisor to go sort of hand in hand with management. So you had that allegation of leak, and an indication that there was nothing in the record that the committee knew about it. So that's the one thing you want to do as counsel to a committee and trying to set up a good process is trying to get the information that you can glean that's happening outside of the committee room, and then have the committee react in the appropriate way and get it in the record, as you heard from the last panel. Getting it in contemporaneous minutes is very important. With the selection of advisors is important as well. Again, in the Empire transcript, as Mike said, they indicated that the board selected the advisors, financial and legal, to the committee members. And the committee members should have a role in the selection of their own advisors. And sometimes the committee members might find that it's beneficial to use company counsel to the extent they're not conflicted, they're new on the scene, they haven't been around for a while. But at the end of the day, if there's going to be a decision with respect to who your advisors are going to be, and to the extent there may have been a financial advisor who had done a little bit of work for the company, but if it's a fast track and the committee makes the decisions, and that's reflected in the record, that's important. Of course, at the end of the day, independent advisors is important, and if the committee can decide that notwithstanding prior relationships, that the advisors are independent, you want that to be in the record as well. The other key issue was the projections, and Mike had said, you know, the management was involved in the projections. And I think management is generally advised in putting together projections. That's not something that committee members are doing regularly, or my experience really, if ever. But to the extent you have issues with respect to the projections, the committee should look to its own independent financial advisor to test those projections. And is there something missing? And in this circumstance, the evidence showed that the board, so the committee members as board members, knew that there was this potential new business development. And there isn't any record, any reflection in the record that they considered that and why it may or may not have been appropriate to include those in the projections or not. So it's, I think, all about sort of the record keeping and the process, which is very important. And Pattern is a hard one because, as Mike said, they checked those boxes, right? They had the record. They had rules of the road for members of management in engaging in discussions. And at the end of the day, based upon the enhanced level of scrutiny, the court found that this was, you know, sort of they met the pleading stage at that point in time to go forward. And I'm not sure what more they could have done in that case, candidly, Jennifer and Mike. I'm not sure if you have views there.
Again, it comes down to minutes, right? Like, one of the criticisms of the process in Pattern was that they brought in a second financial advisor that had done a lot of work on the other side, and there was no explanation in the minutes about why they brought in another advisor. Nor was there a sort of good documented set of minutes that explained how management resulted in bringing in the sort of friendly bidder to the table, and there was concerns that they had been essentially acting on their own without the blessing of the special committee, and the special committee didn't do much about it. So then the question becomes, I mean, yes, the special committee should be vested with its own authority to decide who it's going to rely on. Is it going to retain this banker, and are they going to police the conflicts that exist? But documenting why you're making those decisions is key to establishing that those are not sort of procedural oversights that give rise to conscious disregard, but are considered decisions that are appropriate for deference from business judgment.
Let's just shift for a moment and stick with pattern. But as you mentioned, the court there used enhanced scrutiny, but held out the possibility that entire fairness may come down the road in the event there's a determination that there's a controller. And the language when I was reading pattern that jumps out at you is that Delaware law may countenance extending controller status and fiduciary duties to a non-stockholder that holds and exercises soft power that displaces the will of the board with respect to a particular decision or transaction. And there's been a lot of focus, I think, recently in opinions, starting from Tesla. We've seen it in a few others, of this concept of soft power. And can you talk a little bit, Tricia, about sort of what we saw in pattern, as well as what the consequences are with the court seemingly evolving view that maybe stockholding or significant amount of stockholding might not be so important as commercial relationships and other forms of soft power in order to identify a controller.
Yeah, and candidly, that was a surprising potential outcome, that a non-stockholder could be deemed to be a controlling body or controlling stockholders. It's the stockholders who elect the directors, right? And by having that authority to potentially remove them, that's where the control issue comes in. And the idea that somebody who is not a stockholder could have fiduciary duties, I'm still trying to get my head around. Now, we worry is if you have a significant stockholder, or even maybe a significant supplier, vendor, customer, somebody who has a contractual relationship that has a relationship with the directors as well, that relationship impacts the independence of the directors, so that they aren't acting with the sole best interest of the stockholders in mind in a particular transaction, and instead are worrying, well, wait a minute, what is my relationship going to do with this third party going to do to me? And so that way, I think of this soft control perhaps as impacting director independence, not necessarily making that entity a controller with fiduciary duties. Now, in the Pattern Energy case, it's a very complicated set of facts, but the management held about 10%, and they had these ongoing relationships with one of the parties. And so there you had a 10% stockholder, and maybe you could get some sort of aiding and abetting claim with that outside group. But the fact that they could be a controller was an interesting outcome, or potential outcome to me. And it really changes the analysis, because it's one thing to say, well, these directors weren't acting independently of these parties, and therefore you don't have a majority of independent board. But Corwin would still be available under those circumstances. But instead, if you're saying this potential body is now a controller that takes you totally out of Corwin and puts you in or not even MFW. So you're putting in FW, not within Corwin. And so it sort of changes the whole analysis, I think. And for deal planners out there, they need to be cognizant of these potential relationships and how they might be creating this control concept. And to the extent you think you might be able to rely on Corwin, you might not be able to at the end of the day. And I think we all should just keep an eye on that case, because it's going to be interesting to see how it plays out.
I want to get to your reaction now, Mark, on the controlling stockholder issue. But one of the things we heard this morning from the former Chief Justice was the importance with case law of having sort of these predictable pathways, so that from a transactional standpoint, you can kind of plan ahead. And I'll mention we have extensive decks. They'll be available on the Weinberg Center website. But one of the quotes that jump out at you from a recent article from Hammermash Jacobson Strine is, this is their quote: "Our concern is that the amorphous concept of soft power not arising out of stock ownership could be applied to trigger the entire fairness standard and preclude dismissal, where the premise of control involves circumstances that reflect garden variety commercial dealings," which I think touches upon some of the concerns that you mentioned. Mark, sort of what's your reaction to that?
So I have a couple. First, one of apologize for the informality. It's hard to tie a tie with only one working hand. It's funny, this conversation actually reminds me of, even though I was born in Queens, New York, and didn't get educated here early in life, there was a time when my heart and mind became, it was in and with Delaware. And it was when I took a class with Professor Bill Allen. And after a couple of months of the class, I came to him and I said, you tie everything to good faith and bad faith. Why does Delaware have to have a different standard for every day of the week if for you everything is just binary? And he said, yeah, that's because you have to understand the Delaware judiciary. He says the standards are less for the Delaware judiciary as for the other judges who apply Delaware law. It's an effort to get the other judges who don't have that sense of smell, an ability to figure out good faith and bad faith, so they hopefully get it right. And I think that these cases really highlight that. I think it's important to remember that people file cases, they don't always give enough thought to the details. What I'll say, and Pattern is an example of this, there's a lot of cases where we'll get involved and I'll like a case. I don't always sue the special committee. In fact, there's plenty of times when I don't. And I think the most compelling story to tell a judge is actually the one where the special committee itself might have tried to do the right thing, but is being blocked by the controller. And I think that what's important is to have a system where a judge can look and say, this special committee is independent, but they've actually left clues. And you see this in wording in a proxy, in the evidence, in the minutes. They've left clues that says we did the best we could under the circumstances that were before us. And those circumstances aren't always external. Sometimes what they're saying is the circumstances that the controller put us in is why we had to choose this deal despite there being a clearly better alternative. And again, I have a lot of cases where we give up the insurance, because if you sue the special committee, you're more likely to have access to insurance than if you're just suing the controller. But we don't always do that. And I think that Empire is a good example of people who look independent, but when you look at what and we're involved in that, you look at what they did. It's an important check on the process, and to not have a checklist that just says, okay, independent, and they hired advisors, that's it. There has to be a look at the reality of it, and I think the reality is with a lot of the decisions that got made there, they would make it totally justifiable, at least as alleged, for a court to say, yeah, it looks like, maybe I don't see the lack of independence, but it's so different from what I would expect in a truly arm's length negotiation.
Were you a fully functioning? Were you a fully functioning?
Yeah, I mean, a committee, right? I mean, I recently read Chancellor Strine's MFW opinion, and even before that, the idea of a committee is to replicate arm's length bargaining. If you have too many instances of decisions being made that just don't look like anything you'd expect in third-party arm's length bargaining, the court shouldn't credit the committee. And I feel like sometimes we're trying to fit a conclusion into a square peg into a round hole. If the controller's going to overreach, clearly the controller should face liability. It's a harder call to say when you're going to take an independent committee and say that they're acting in bad faith. But at a preliminary level, there's a point at which there's enough to say, I need discovery to know what was the board doing. In my experience, sometimes you can at first be suspicious of the committee, and I've had this in cases, and then we'll drop the committee because we say, oh, you know what, now that we're talking to them, now that we're getting the discovery, sometimes get a proffer from defense counsel, we will see they were coerced, bullied, not allowed to do their job. Pattern is a different, I just want to say on pattern real quickly, I was involved in that. We filed an action. There was a leadership dispute. We made a decision in that case not to sue the committee. We lost in part because we weren't suing everyone we could sue and bring every claim that we could sue. Again, don't know what's going on in the discovery, but our assessment in that case was rather than risk a dismissal, which makes it very hard to bring the committee in later and have a high standard to do that, we actually touted that we didn't sue the committee because we know we'll get discovery. There's no statute of limitations problem. We can bring them in if the discovery further supports the claim. So, I guess I was wrong about pattern.
Let me ask you a quick question, and then I want to turn to multi-plan. But going back to the controller issue and the discussion in pattern, from a plaintiff's perspective, are you finding that your pleadings are different, you're approaching a case different, given this focus on, or seeming focus on soft power and the effects of Corwin, as Tricia was talking about?
Yeah, I think, I don't know if the pleadings have evolved. I think that, again, you think about the standards and people are trying to click in. Factually, I think Aronson versus Lewis, I think Mr. Harry Lewis was the controller. He had 73% of the shares, and the court's conclusion was he wasn't a controller. It was more than a majority. And I think that was because it was taking a realistic look. And so, soft power, I don't know that I'd go to the extremes of you don't have to be a shareholder. I've come close and was wrong about that. But I think there are situations realistically where, again, you can have someone at 30% or even lower, but is a shareholder, but has all sorts of other levers to pull to influence the company. And I think that just like in theory, you could have a controller who basically disables themselves. And that's like, perfect MFW process is, I'm thinking of making a proposal, go ahead and do what you need to do. And it's really arm's length from the first moment, and it's truly arm's length. I don't have a problem pleading a case where I say, look, it's not a majority shareholder, but look at all the levers of power that this person has, and there's a history of using it, or in this case, they used it. Again, that's why independent directors can't always get to arm's length bargaining, even if they try. And it's because sometimes the controller or large investor will use their power to essentially prevent the special committee from replicating arm's length bargaining.
So I think the challenge is if soft power ends up being a very gray line, it allows the court an optimal ability to look into the key facts of that case and decide how did they exercise that power, how did it actually come out, and did they do the right thing in the context of that case. What you lose, I think, is by not having a bright line is, aren't we systemically better with a brighter line that says you're a controller under this theory, and as a result, you have fiduciary duties now. You have a duty to do X, Y, and Z, as opposed to being surprised in litigation on damages claim a year later that, wow, you're a controller, or you're part of a control group because you're aligned with somebody else who did. So as much as I think as litigators we can become sort of focused on this idea that being able to address the facts of each case is both an appropriate way of doing justice and consistent with our common law system, it does sort of create the issue of, if we don't have a bright line, we're losing the fact that if we had a bright line, more people might recognize that they were fiduciaries and might not do X, Y, and Z in a deal process because they know that they're constrained by the fiduciary duty. And I do think that becomes awfully problematic in a situation where people are taking commercial relationships that they contracted for and turning that into a tort, essentially a potentially tort liability scheme in which they've got duties to act in a non-commercial way on behalf of others that they didn't know that they had.
Yeah, and I get that, you might like the appeal of a bright line rule. It just seems very hard with so many facts and circumstances. And so I think that a court of equity probably needs the ability to react to the different facts as they see them. And I'm not sure why not in the pattern case that the non-stockholders, it isn't enough for them to be on the hook for an aiding and abetting theory with respect to the officers. Like, why do we need to go that next step? And so they can still exercise their commercial rights, right? But if they're using their influence over officers and management of the company to drive to a certain way, then they face aiding and abetting liability. And now the fact that I hear you, Mark, that you don't think that a non-stockholder, could be a controller, but why isn't aiding abetting enough to get us there? And I think everybody needs to be, and that's the aiding and abettor's concern, right? Not the transaction planner's concern.
I'm gonna end this conversation, although it could go another 2 hours. Justin had asked us to briefly, I think, talk about multi-plan and SPACs. I'll give you a preview. I believe that the Weinberg Center is going to be putting on a much larger conference later on this year regarding SPACs, including plaintiffs, academics, et cetera. We have the privilege of having Mark here, who litigated the multi-plan. We're going to assume a basic knowledge of SPACs and the de-SPACing transaction. I'm just going to give a couple quick comments to set the stage, and then I'll turn it over to Mark. I think it's unclear what 2022 is going to look like in terms of SPACs and de-SPACing. There's a fair amount of uncertainty, including what the SEC is going to do. We're expecting some pronouncements in April that may mean increased regulation. There's also obviously challenging economic situations right now that's, I think, slowing down the SPAC market. And there's also some disappointment, with the results of companies that have gone public through the de-SPACing process. But what I think is a certainty is we're going to see more litigation, including on those the companies that went public in 2021. We're starting to see the lawsuits roll in for those. I think the issue that we want to kind of tackle today, in addition to discussing multi-plan and what you see coming down the road, is this perceived misalignment of interest between the Class A and Class B, or I should say the sponsor founder shares of the Class B, and then the folks who got their Class A shares through the IPO. And the gist of the misalignment being without a transaction being concluded within the 24-month window that you typically see, the sponsor gets nothing, and the Class A can redeem. They don't have to go. They can get their money back from the IPO if there's no transaction. If there is a transaction, they have the redemption right. The issue in multi-plan was whether or not the Class A stockholders, I think, had sufficient adequate information in order to make that redemption decision. But let me stop there in the interest of time and turn it over to you, Mark.
Yeah, and I'll try to be quick. And what I want to do in talking about multi-plan is kind of share some of my thinking. There was a lot of work before we even understood doctrinally how to present the case. I just want to say, look, there was a SPAC frenzy, and even before we touch on multi-plan, there's a lot of other litigation. We keep seeing cases where people were pumping out deals so quickly that there's basic statutory violations. What we've seen, violations of Section 242 where they're not soliciting the right vote. That's just basic stuff that in a normal corporate deal, that doesn't get messed up. And I just think that, there was a speed and a fury almost to the way these SPAC deals were being done, that you see mistakes. Something that we've recently found, and they're getting corrected and mooted, is some of the SPACs don't have, and it's well easy to fix now. SPACs didn't provide for written consent, and that's not allowed under the statute unless that's in the charter. But the bylaws of SPACs didn't allow for written consent. When it's a SPAC, there's reasons why it's not as big of a concern. But we've seen companies become operating companies after a de-SPAC. They keep the old bylaws. And again, it's just because of the speed and fury of these deals. You can't do that under Delaware law. And so I think there's a lot of avenues, a lot of problems in the SPAC space that'll work itself out. But turning to maybe before multi-plan, but really the bigger picture thought on SPACs, we didn't just shoot off that first lawsuit. Actually, in the summer of 2020, maybe part of COVID is, spending too much time on other things. I spent a lot of time trying to understand this because of this conflict. because I started to see what SPACs are. I had some clients, actually hedge fund clients who were getting involved in the PIPE financings, calling with questions. And as soon as I looked at it, again, taking just a non-doctrinal view, I was like, this is so conflicted. I mean, who ever heard of a situation where a board, the whole board and the controller, can take 20% of the equity? And the first way I thought of it is hedge funds work on 2 and 20, right? And that's a lot of profit, but it's only 2% of the asset value. This is basically 20% of the asset value once you close a deal. And so I inherently was focused on the conflicting interests, really struggled with how it fits in Delaware doctrine. And it's because of the redemption right. And I'd like to focus on that because I think that a lot of people have focused on multi-plan as being like a disclosure claim. The way I thought of it is, under normal circumstances, if you don't have the redemption right, this is an easy entire fairness claim, right? There's no independent directors, no committee, no process, no majority minority vote. You're in an entire fairness claim, and it's deeply conflicted. The problem and the hesitance I had was not that redemption was going to create a new claim, but that it's going to block the claim. Because if a stock is trading above 10 even after a deal, you're not injured. But if it trades below, the question is, well, you could have gotten out at $10. And so in a world where entire fairness is fair process and fair price, one of the elements of fair process is disclosure. Not the only one, it's just one of them. You can have entire fairness claims in other contexts where you don't hit the disclosure prong, there's other process problems. But the struggle that we had, which is kind of very different from the way I think people are perceiving it, was the $10 kind of goes to, the fair price. Like how, if you had an informed ability to get out at 10, how can you complain that the controller and board did a terrible deal? Like if they're telling you, we're going to take your $10 million that you put into this bank account trust, which is the SPAC, and we're going to spend it on $1 million of rubble, but we're disclosing it. The answer is mitigation of damages. Is the redemption right is in a way to opt out of your investment in a way that's not present with operating companies. So when we finally put that together, it wasn't like this epiphany of great, it's a disclosure claim. It was, there is a way to deal with the redemption right that doesn't blow up essentially the possibility of harm even when people are staying in the investment. And in fact, I think that the way that SPACs work right now does lend to the conflicts, and I think that the question is not as simple as what did the stock do. Delaware doesn't really do event studies, normally, and it doesn't look to stock price, more so in the appraisal context, I guess, but it doesn't really look at stock price primarily. And I think you're going to see a traditional fairness analysis and say, okay, I had something. It was my pro rata interest in a trust, a bank account. What did I get because of this unfair deal? Is stock in a company as of a certain date, and I think the question is, was that company worth less than the cash in the account? And what I'd say is, it shouldn't even be that hard to do a deal that's valuable, because you just have to make an investment that's better than letting your money sit in cash. But because of the dilution factor and because of other factors, you're seeing a huge number of SPACs that have blown up after the deal.
We have Justin approaching the stage, so let me have two or three more minutes here, and I want to turn to Tricia. Without getting into legal advice that you're giving to clients on SPACs, et cetera, we've seen a lot of takeaways in the legal market generally. There's some discussion of should you be creating special committees. There's also been some discussion on compensation issues and how the board members of the SPACs are being compensated, the compensation tied to the sponsors' Class B shares, et cetera. Can you just give us a couple minutes of your thoughts on these issues?
Sure, very quickly. I think you are seeing people starting to talk about putting independent directors on the SPAC boards. That could involve avoiding serial SPAC directors. So that you're not on the same, multiple SPACs of the same sponsor. Starting to see the creation of, if you have those independent directors, the creation of special committees to help analyze the de-SPAC transaction. looking for fairness opinions as to whether the price paid is fair to the SPAC. Not all financial advisors, or my understanding, are giving those types of fairness opinions, but I hear that there are some that are out there. And as to the director compensation, I've heard maybe some rumblings of maybe these, some independent directors might not be getting the sponsor shares and might instead be getting a flat fee. I don't think that that's necessarily market by any means. And I guess the one thing I'm struggling with a little bit is, the idea that, what is material from a director fee perspective to a director. And I know in the multi-plan case, there was a suggestion that $500,000 payout is presumptively material. And look, we vet the independence of committee members all the time, and we talk about their director fees and whether they are material to them. And we often, if they're serving on an independent committee, we get them, saying back to us, no, those fees are not material to me. And to sort of the earlier point by the chancellors and Mike's point of having a predictable system, and if the system tells us we can put in an independent committee of directors and if we have a vote, we can get out at Corwin, or if we have MFW, that's great. But if at the end of the day our independence is getting tested because of director fees, I'm not sure if we're not getting out at a motion to dismiss. Now, maybe that's not the end all be all. Maybe you can still get out at a motion for summary judgment. But I don't know, Mike or Mark, if you have any views of just if a director is on the record, on the minute, saying that amount is not material to me and therefore I am independent. I'm not sure.
Look, and I think they have a lot of additional ties, but I will tell you, I love what I do. I love practicing this law. Maybe I would do it for free, but if I said I don't care about the money, I don't think anyone in the room would believe that just inherently. And I don't think you can have that standard. More importantly, it's true. I really do love what I do, but and that's the driver. However, I don't think you can have a rule of law that says if someone says I don't care about money, you're going to ignore it. And I think that, this is contingent money also. It's $500,000 of you get zero, or $500,000. That was the lowest pay for that director. But I think in general, the contingency is enough to create a conflict as long as it's any meaningful amount of money. And I think it's fair to say $500,000 is a lot, and people become billionaires because they don't throw around $500,000 loosely. It's a lot of money, but so.
But that's what we're seeing, I think, on the SPAC front and developments, and people
good
giving
governance.
some thought.
That was kind of the point in paragraph 1 of multiplan is there's SPAC 1.0 and we're going to SPAC 2.0. And what that is good governance matters. So I love hearing that the SPACs are being run with better governance.
Thank you all very much. I appreciate it. And thank you for coming today to hear us.
Thank you, Jennifer, and thank all your panelists. That was really a very thoughtful program, and we really appreciate it. And I guess I would just say in conclusion that all of the panels that we had today are really examples of the excellent programming that Weinberg puts on and that we're known for. And I'm incredibly proud of that, and incredibly proud to have Chancellor Bouchard as the chair of our advisory board. Just on the administrative side, sign the CLE exit form, or the sheet that says that you've been here for the required amount of time, and we do have a lunch in the room right next door. Thank you all for coming. Thanks for your attention, and we do hope to see you at future Weinberg programs. Thanks so much. Thank you.